So this is a topic on director. So under this topic, we are going to discuss as to who is really the director, when his office will become vacant, so how he is going to be terminated, and what are actually his duties as a director. So who is actually a director? So a company is only an artificial person, and because of that, they cannot act in their own, and they need a natural person to act on their behalf. And actually, this task is being entrusted to a body or persons who is being to a body or persons who is being called directors. So under section 196 subsection 1, if this is a private company, then the minimum number of directors which is required is 1 director. Whereas if this is a public company, the minimum number of directors which is being required is 2 directors. And under section 196 subsection 4, the minimum number of directors which is being prescribed earlier shall ordinarily reside in Malaysia and have a principal place of residence in Malaysia, and this shall not include an alternate or substitute director. And under section 14, the names and the particulars of this director must be specified in the application for incorporation of the company, and a statement confirming that he consented to this to become a director must be stated inside this statement, and he also must not be a person who is being disqualified under the Companies Act to become a director. So the definition of a director under section 2 subsection 1 of the Companies Act, there is no such comprehensive definition of a director. So under the said act, it only includes these people as a director. So under section 2 subsection 1a, it says any person occupying the position of director of a corporation by whatever name called, and these include B, a person in accordance with whose directions or instructions the majority of directors of a corporation are accustomed to act, and C, an alternate or substitute director. So under this definition, we can say that if any person occupies the position of a director, though he is not called as a director, however, the position is like a director, then he is considered to be a director. And if that person also, if the directions or instructions is people in that company is accustomed to act to his directions or instruction, he will also be considered as a director under that situation. So this director actually is not the employee of the company unless there is a separate contract of employment whereby actually he is a salaried executive between him and the company. If not, he is not to be considered as an employee of the company. However, he is rather as an agent of the said company. So in practice, actually, there is a distinction between the non-executive director and the managing or executive director. The non-executive director, this is the director that takes part in the collective decision of the board of directors but has no other function except by express delegation. So meaning this is the kind of directors which actually attend meetings, and they did not manage the company. However, they are entitled to vote during the board meeting. Whereas the managing or executive director, so this apart from the task which is being performed by the non-executive director just now, so meaning he did this task, he attend meetings, he vote during the board meeting. In addition to that, he also take part in other work, and most of the time he is a full-time director, meaning he is the one who manages the company. So how the directors is being appointed? So under section 14, subsection 3, subsection F, the first director will be named in the application form. So once the application form is being filed with the CCM, Commissioner of Companies Malaysia, the name of the first directors have to be stated in this form. So this is how the first director is being appointed. So for a subsequent directors, so meaning directors after that, after the first AGM, according to section 202 subsection 2, so all subsequent directors of the company may be appointed by ordinary resolution. And under section 202 subsection 3, the board of directors also may at any time appoint a director in addition to the existing director, and this director which had been appointed, they shall hold office for a public company until the next AGM, while for a private company, this is according to the terms of appointment of this director. So for companies which have constitutions, certain companies, they have constitution. However, if the company does not have a constitution, so of course, they need to follow the procedure or the provision inside the Companies Act. So for those companies which have constitutions, that the constitutions may put the provisions that a certain person or body will have the power to appoint the directors of the company. So as an example, for a private company with small number of members, they can put it inside the articles of the constitution that the directors shall be appointed by the members. And for wholly owned subsidiary company, they can put it inside the articles and authorize the holding company to appoint or to remove its directors. And sometimes the certain companies put it inside the constitutions for holders of the debentures stock, whereby they are being given the right to appoint a director, or the appointment of directors is being granted to an outsider in a separate agreement under that situation. So now we are going to discuss under section 208 as to how the office of a director of a company will become vacant. Okay, so under this section, under 208 subsection 1, the first one is when the director resigned. So the director can resign by giving a written notice to the company at its registered office. One. And secondly, when the director retired in accordance with this act or the constitution of the company, and he is not being re-elected during the AGM. And thirdly, when the director is being removed from his office in accordance with this act or the constitution of the company, if the company have a constitution. And number 4, when the director becomes disqualified from being a director under section 198 or 199 of the Companies Act. And number 5, when the director becomes of unsound mind or a person whose person or estate is liable to be dealt with in any way under the Mental Health Act 2001. And number 6, when the director dies. And number 7, when he vacates his office in accordance with the constitution of the company. So under that situation, the office of the director will be vacated. So now we are going to look at the qualifications of directors. So under this, we are going to look at who can be appointed as a director. And then we are going to look at number 2, the share qualification of a director, and also how a director can be disqualified by court. So we are going to look at who can be appointed as a director first. So under section 196, subsection 2, so a director must be of a natural person and he must reach the age of majority, meaning he must be of full age, which is 18 years old. And under section 196, subsection 4, he must ordinarily reside in Malaysia and having a principal place of residence in Malaysia. And according to the case of MY versus Comptroller General of Inland Revenue, the judge held that what is meant by a place of residence in Malaysia is that to be a resident in a place, an individual must first reside in that place, and in the case of absence, such absence are temporary and reasonable. So, and then in number 3, who can be appointed as an auditor under section 198 subsection 1, a person cannot hold office as the director of a company, whether directly or indirectly, be concerned with or take part in the management of a company if he is an undischarged bankrupt, B, if he had been convicted of an offence relating to the promotion, formation or management of a corporation, C, he has been convicted of an offence involving bribery, fraud or dishonesty, D, he has been convicted of an offence under section 213, 217, 218, 228 and 539 of the Companies Act, and E, he has been disqualified by the court under section 199. So, for A, B, C, D, this is applicable though the circumstances occur in or outside Malaysia. And for an undischarged bankrupt, he may be appointed as a director with the leave of the official receiver or the court, and a 14 days notice must be given to the registrar of companies of this intention to be appointed as a director though he is a bankrupt. And if a person has been disqualified under C, D, and E, so these are those persons who have been convicted for certain kinds of offence, and those persons have, and for those persons who have been disqualified by the court, they may hold office as a director also with the leave of court. However, after the expiry of 5 years, there is no need to obtain the leave of court. And under section 264, subsection 1, subsection III, if a person is an auditor of that company, then under that situation, he also is not entitled to be appointed as a director. So we are going to go on with the qualification of directors under II. So actually there is no provision under the Companies Act which impose that a director needs to have a certain share qualification. However, this may be provided in the constitution of the company. And why is it so? For certain companies, they provide it inside their constitution that directors must possess certain amount of share. The objectives of this is, firstly, to impose upon the directors a personal interest in the affairs of the company so that the directors will have an added incentive to ensure that the financial success of the company. Since if the directors also have a share in the companies, so he will make sure that the company will be a successful company. Because if not, his share will be also in a risk. And secondly, this is to make it attractive to shareholders, because once they see that the directors are risking their own money, so actually their position is the same as the other members. And because of that, under that situation, the shareholders will be attracted actually to join the said company. So if there is such a qualification which is being prescribed by the Constitution, then under that situation, the director have to fulfill this qualification within the period time prescribed by the Constitution. In the case of Holmes versus Keyes, whereby in that case, the Article of Association required the director to acquire qualifying shares within 2 months after the election of the directors. And actually, under Section 206, if the director fails to fulfill this requirement, he might be removed under that section, and he is incapable of being reappointed as a director until he have fulfilled this requirement, meaning until he have gained the amount of share which is being required under the Constitution, then only he can be reappointed again as the directors. We are still discussing with regards to the qualification of directors. So under III, so a director can be disqualified by the court. So under section 199 subsection 3 of the Companies Act, sorry student, so under section 199 subsection 1 of the Companies Act, it provides that the court may, on application by the registrar, make an order to disqualify any person from acting or holding office as a director or promoter of a company, or be concerned with or taking part in the management of a company, whether directly or indirectly, if within the last 5 years the person has been a director of 2 or more companies which went into liquidation resulting from the company being insolvent due to his conduct as a director, which contributed wholly or partly to the liquidation. And secondly, if due to his contravention of the duties of the director, or thirdly, due to his habitual contravention of this act. So meaning under this situation, under these 3 situations, the registrar of companies can make an application to the court to disqualify a person from becoming a director. Because why? Because within the last 5 years, he had become a director or a promoter of a company, and that company had went into liquidation and had become insolvent because of his conduct. Or secondly, because he have contravene his duties of a director before this, or it is his habit actually to contravene the provision of the Companies Act. And under that situation, he might be disqualified from becoming a director. Our next discussion is with regards to retirement, removal, and resignation of a director. So we are going to discuss with regards to retirement first. This is under section 205 of the Companies Act. So if there is a provision inside the Constitution with regards to how a director would retire, then follow the terms of the Constitution. So under Section 205, Subsection 2 of the Companies Act, for a private company, they may pass a written resolution to determine the retirement of a director. Whereas for a public company, under Section 205, Subsection 3, a company director shall retire as follows. Firstly, at the first AGM of a public company, all directors shall retire from office at the conclusion of the meeting. Why? Because then the members of the company shall determine with regards to the appointment of directors. And secondly, at the AGM in every subsequent year, 1/3 of the directors for the time being, or if their numbers is not 3 or a multiple of 3, the number nearest to 1/3 shall retire from office at the conclusion of the meeting. So who should retire first? The longest in office have to retire first. So if they become directors on the same day, then under that situation, it shall be determined by lot or through consensus. So meaning, if all parties consented as who should retire, then it will be easier. If not, it will be determined by lot. So meaning, this will be determined by a choice of chance. So meaning, the members there will actually put an object like shilling or so ever, then through that shilling, they will determine who actually will resign then. So this is like when, like a football game, you determine who actually will start the game is being determined through a shilling. So this can be done also under this situation. So if the director is not being disqualified under the Companies Act, then under that situation, they can be re-elected again. So now we are going to discuss pertaining to removal of directors under Section 206. So a director can be removed before his term of office expired. So if this is a private company, then we follow what is being provided under the Constitution. If it's not being provided under the Constitution, then it can be done through an ordinary resolution. However, if this is a public company, then cannot follow the Constitution. However, it needs to be done through an ordinary resolution. So if a director is to be removed, a special resolution to remove or to appoint another person at the same meeting should be done. So meaning a special notice is required here. And under number 4, if a director of a public company was appointed to represent the interests of any particular class of shareholders or debenture holders, then the resolution to remove the said director shall not take effect until the director's successors has been appointed. If a director is to be removed, of course, under that situation, as natural justice need to be given to him, under Section 207, he must be given right to be heard. So, if this is a removal, the procedure is that, number 1, a special notice for a resolution to remove a director is required to be sent to the director which is to be removed. And secondly, this director shall be given the right to make oral or written representation not exceeding a reasonable length on the resolution to remove him. And number 3, if the director made a written representation and request to notify the members of the company because he wanted to state the fact of the representations in the notice of the resolutions, and he wanted it to be sent to every member, then under that situation, under number 4, the company need to do so. If not, the director may request that his representation be read out at the meeting. So number 5, only if the court is satisfied actually that the director is abusing his right, then only there is no need actually for the company to send the representation to the members of the company. So let us have a look at the case of Solia Pan versus Lim Yok Fan, whereby under this case, the article of association of the company provided that a director may be removed by giving him a 7 days notice before the general meeting. The plaintiff then sent a notice of a resolution to remove the directors 3 days before the general meeting. At the meeting, the plaintiff was then purportedly elected as the director after the defendant had been removed. However, the defendant refused to vacate the office. The federal court held here, though it's been provided under the Companies Act, that the necessary notice which need to be given to the director which is to be removed is 28 days. However, this is not mandatory. If it's being provided somewhere else, if it's being provided inside the Constitution, then under that situation, then the company need to follow the provision of the Constitution. And in this case, from the facts actually, the notice had not been given properly because the Constitution provided that it must be a 7 days notice. However, the notice which had been given to the director is only a 3 days notice. And because of that, the defendant had not been properly removed, and consequently, the plaintiffs also were not properly appointed as a director under this situation. So now we are going to discuss under section 209, resignation of director. So under section 196, subsection 3, a director cannot resign from his office if it will result in the number of directors falling below the minimum number of directors required for a company. And I have discussed this. The minimum number of a director in the public company is 2 directors, whereas if this is a private company, 1 director. And under section 208, subsection 2, a director may, subjected to section 196, subsection 3 just now, the minimum numbers of director, and section 209, which I'm going to discuss after this, resign by giving written notice to the company at its registered office. And under section 209, a sole director shall not resign until he has called a meeting of the members to receive notice of the resignation and to appoint 1 or more directors. So because if a sole director is being allowed to resign just by giving notice, then under that situation, the company would not have a director at all. So this is actually wrong under section 196 subsection 3, whereby there need to be a minimum number of directors in existence. So now we are going to discuss the duties of directors. Directors have 3 duties: fiduciary duties, statutory duties, duties of care and skill. So we are going to discuss all these duties in detail in the following slide. So let us discuss the fiduciary duties of a director under section 213 subsection 1. So under section 213 subsection 1 of the Companies Act, it says that a director of a company shall at all times exercise his power in accordance with this act for a proper purpose and in good faith in the best interest of the company. This shows that the directors occupies a fiduciary position in relation to the company, and therefore they must exercise their power in good faith in the interest of the company as a whole. So, if we break up this section 213 subsection 1, actually the fiduciary duties of the directors are three kinds of duties. The first one is to act bona fide in the company interest. Second one, to exercise his power for proper purpose. And the third one is to avoid any conflict of interest between his duty to the company and his personal interest. So we are going to discuss the first one. This is the duty to act bona fide in the company interest. So a director is said to act bona fide in the interest of the company when he acts in what he honestly considers to be the company interest and not some other party's interest. So the meaning of honestly was being considered in the case of Marchase versus Barnes and Co., whereby the judge states that to act honestly refers to acting bona fide in the interest of the company in the performance of the functions attaching to the office of the directors. What is meant by acting bona fide in the interest of the company in performing of the functions attaching to his office can be seen through the case of W&M Ruth Limited. In this case, Ruth, the director and controller of the company, entered into an agreement with the company to provide payment of pension for his wife upon his death. And this claim for pension was then made by the wife after his death. And the court held that the company is not obliged to pay this pension because when the directors made such decisions, they were not considering the interests of the company. The company, in fact, did not derive any benefit from the state agreement. And in the case of Percival versus Wright, the court held that the interest the company directors have to consider actually is the interest of the members of the company as a whole, not the interest of individual members. And in the case of W&M Ruth Limited, this is the interest of an individual members. And because of that, cannot be allowed. So now, during the recent years, the company interest also include the employees' interest. This is very different from the case of Park versus Daily News Limited because this case is not applicable anymore because in this case, the director were had breach of their duty to the company when they considered the employees' interest above that of the company. So if this case is going to appear now, the decision will differ because now a company interest also include the employees' interest. And lastly, if let's say the company is in the state of insolvency, meaning the company now cannot afford to pay their debts, then the creditor interest will become the interest of the company also. And these need to be taken into account as well. And under that situation, the directors then owed a duty to the creditors to see that The assets are managed in such a way that the interests of the creditors are not at risk. So in the case of Walker versus Wimborne, the court found that the company directors is in breach of their duties to the company and its creditors in giving guarantee loans for another company in the group at a time when the company was itself in a serious financial difficulties. So, this is the fiduciary duties. The second fiduciary duties of a director is to exercise power for a proper purpose. So this requirement is under section 213 subsection 1, whereby the director must act for a proper purpose. The powers which is given to the director must not be exercised for any improper purpose. So what is meant by improper? Improper means something which is being done beyond the scope of the instrument creating the powers. So, if the power is exercised for an improper for something which is improper purpose, then we said that the director is in breach of his fiduciary duty. Even if the directors insist that they honestly believe it is in the interest of the company. So, how are we going to determine whether the director did something beyond the scope of the powers given to him? So the powers of the director, if there is a constitution, we need to look at the constitution as to what are the powers of the directors. If it goes beyond than this, then under that situation, we said that he did something beyond the constitution. So the court will actually consider two factors under this situation. What are these two factors? So I'm not going to discuss a reintroduction because I have discussed a reintroduction earlier under other topics. So we are going to go on with what are the factors which will be considered to determine whether the directors have exercised his power for something which is proper or not. Two factors will be considered by the court in determining whether the powers which is being exercised by the director is proper or not. The first one, look at the objective for which the power was granted. This objective is inside the Constitution. So, what is the objective of the said company? And secondly, the purpose for which the power was exercised by the directors. Is this purpose for the said objective? If the said purpose is for the said objective, then he did something which is proper. However, if the purpose is not for the said objective, then we said that this is not a proper purpose. So the director are in breach of their duty if they exercise their power for a purpose other than the purpose for which the power was conferred on the director. Okay, so let us have a look at the case of Redomatic Limited to understand this more clearly. So in Redomatic Limited, the directors made payment to a former director as compensation for loss of office. Then they were not aware that actually under the UK Companies Act required them to notify the shareholders before doing so. And because of that, the payment was thus unlawful. And the court held that although the directors had acted honestly due to the ignorance of the law, the directors were liable for misapplication of the company's fund. Why? Because it is not allowed under the Companies Act. It's similar. If it's not allowed under the Constitution, as I told you just now, they cannot do this because that is beyond their scope, beyond their power. So, example, we are going to look on the case of Howard Smith after this. So, if the power is to issue share to enable the company to raise money or secure other advantage for the company. So meaning the directors have power to issue share. However, if they issue share contrary to this purpose, they issue share because of other purpose, then this is actually not for proper purpose, meaning that the directors have breached their fiduciary duties. So this is what happened in Howard Smith Limited versus Empire Petroleum Limited, whereby in this case, the plaintiff and the defendant companies, they involved in an attempt to take over R.W. Miller Holdings Limited. Actually, the defendant Empire Petroleum had enough share to block Howard Smith in succeeding in their bid. However, the board of directors of R.W. Miller, they favored Howard Smith. They don't want Empire Petroleum to take over of their companies. And because of that, they issued shares to Howard Smith in the intention of reducing Empole's share so that they can block the takeover bid attempted by Empole Petroleum. Okay? And because of that, Empole Petroleum now challenged the validity of the shares issued by R.W. Miller Holdings Limited. What the court held in this situation? The court held that the director had breached their duties by improperly exercising their powers, and the issue of share to Howard Smith was invalidated. Although it's true that the company could make use of the additional capital, however, the issue of the share was not because they need the capital. The issue of share, the intention is that they don't want Howard Smith to succeed. The issue is that because they want Howard Smith to succeed in their takeover. So this is actually not a proper purpose. So a director may not issue shares to others to change the balance of power within the company by destroying the existing majority. So this is what is being done by R.W. Miller. They issue share to destroy Empole Petroleum. So even where there is absence of self-interest. So in fact, in our Malaysian law, we have section 75, subsection 4 and subsection 5 as to how a director can issue shares, under what circumstances. So because of that, where the directors issue shares to themselves to maintain control over a company, the court will also definitely set aside such issue even though the full value had been paid on the shares. This is what happened in the case of Poon versus Siemens, because in this case, the directors issued new shares with the object of creating a sufficient majority to enable these directors to pass a special resolution depriving other shareholders of special rights conferred on them by the company's articles. So this is actually wrong because this is not for a proper purpose. The fiduciary duties number 3 of an auditor is to avoid conflict of interest. A director should not put himself in a position where his personal interests conflict with the interests of the company. He is not allowed to make use of his position as a director to obtain profit for himself. So in fact, under Section 242 of the Companies Act says that a dual capacity is not allowed, whereby a director cannot hold an office as a director for two companies unless the other companies is being notified when he discloses of the situation. So let us have a look at Section 218, subsection 1 of the Companies Act, because these are the situations when we said actually there is a conflict of interest. So if a director or officer of a company, without the consent or ratification at the general meeting, did the following, then this will be considered as a conflict of interest. Firstly, he used the property of the company. And secondly, he used any information acquired by virtue of his position as a director or officer of the company. And thirdly, he uses his position as such director or officer. And fourthly, he uses any opportunity of the company which he became aware of in the performance of his functions as the director or officer of the company, or he engaged in a business which is in competition with the company. And he did any of this is because he wanted to gain directly or indirectly a benefit for himself or any other person, or he wanted to cause a detriment to the company. So this is wrong, and under section 218 subsection 2, if this is being done, then that person is liable to imprisonment for a term not exceeding 5 years or a fine not exceeding 3 million ringgit. So let us have a look at the case of Aberdeen Railway Company versus Blakey Brothers. So this is the case of conflict of interest, whereby a railway company entered into a contract with a firm to supply iron sheets, and actually one of the partner of the firm is the director of this company. And later on, the company wanted to set aside the contract. One of the reasons given is that the partner of this firm is actually the director of the company at the time of the contract. And the court held that the company could actually set aside the contract even if it was made on fair terms. And in the case of Quinners PLC versus Saunders, a committee of the company had without authority awarded a director of a company remuneration of £5.2 million in return for his services in a successful takeover bid. And the court rejected the claim by the director for this amount of remuneration, okay, because the court pointed out that a fiduciary must not place himself, meaning this director cannot place himself in a position of conflict and may not profit from his position except to the extent allowed by the Articles of Association. Okay, we were discussing with regards to conflict of interest. What are the situations which we said that there is a conflict of interest arise? So there are three situations when we say that there is a conflict of interest. The first one, where the director compete with the company. Second one, where the director use the corporate property, information or opportunity. And the third one, where the director contract with the company. So we are going to look at these one by one. So we are going to look at the situations when actually the director compete with the company. So a person may be a director of more than one company as long as he discloses any potential conflict that can arise out of his position in those companies. He cannot allow one company's interest to have priority over the other. And this is very, very clearly stated under Section 242 of our Companies Act. And secondly, a director cannot compete with the company for whom he acts. He cannot set up a competing business to take any property or benefit that properly belongs to the company of which he is a director, or if he takes for himself any business advantage for which he was negotiating for his company. A director would be in breach of his duties if he set up a competing firm to take advantage of contracts that should have gone to the company. Let us have a look at the case of Cook versus Diggs. So what happened in this case is this TCC tendered for a contract with a railway company. And this TCC company had 4 directors. And 3 of them could not get along with the director number 4. So when the contract was awarded, these 3 directors then set up a new company and they deferred the contract to this new company. So the contract which they obtained earlier, they deferred it to the new company. So being the majority, they passed a resolution from TCC rectifying this conduct. And the 4 shareholder, of course, the directors number 4 was not happy towards this situation, and it took up an action against the other 3 directors, claiming that they were in breach of the duty and they had to account their profits to TCC. The court held that the directors were in breach of their duties when they set up a competing company to take over the contract that should have gone to the company in which the 4 of them were directors. And because of that, actually, the profits actually belong to CCC. So what happened if, let's say, the director resigned, and after he resigned, then he took the opportunity. So even after a director resigned, a director is still liable for the breach, especially if he resigned because he wants to take the opportunity himself. This is what happened in Canadian Aero Services Limited versus O'Malley. The court held that the president and the vice president of the company is liable where, after having negotiated a contract on behalf of the company, they resigned and they formed a new company and acquired this contract for the new company. So, what happens if a director gets a contract where his company has no chance of obtaining the contract at all? Is he liable for breach of duty because the opportunity came to him by virtue of his position in the company? So let us have a look in the case of Industrial Development Consultant Limited versus Cooley. In this case, the defendant Cooley was the managing director of IDC, of Industrial Development Consultant. So IDC attempted to obtain a contract with EGB, but this EGB company was not interested in contracting with IDC. However, they are more interested in engaging Cooley himself. So what happened here? Cooley then resigned from IDC using ill health as an excuse, and then he began working on a project whereby IDC was interested earlier. And when IDC found out about this, they sued to recover all profits that the defendant, that Cooley, had obtained under the contract with EGB. And the court held that although IDC would not have obtained the contract at all, the defendant Cooley was in breach of his duty to IDC because he did not fully disclose to IDC all information he obtained in the course of his dealings with EGB. As such, he was liable to account all profits he had made to IDC. Okay, the second conflict of interest is when the director used the company's property, information, or opportunity. So a company's property, information, and opportunity are all assets of the company. A director may not use them for his own benefit. A director may not use the company's money or assets to make profit for himself. All the money or assets must be used only for the company's benefit. A director also may not use information acquired by virtue of his being the company's director for his own benefit. So, in the case of Grove versus Flower, The court held that a director who knows that his company is facing the risk of insolvent liquidation is acting improperly when he uses that information to protect himself, and other companies of which he is director from the consequences of that liquidation to the detrimental of the creditors. So under this situation, what this director did is that he made use of the information to protect himself. And this is actually wrong because those information is the property of the company. And any misuse of trade secrets and other confidential information is also amounts to conflict of interest. Therefore, there is a breach of duty on the part of a director. So let us have a look at the case of Thomas Marshall Exporters Limited versus Gunley. So Gunley, the managing director of a company, had, without the company's knowledge, began to trade on his own in competition with the company. The company then sought for an injunction to stop him from disclosing or using the company's confidential information or trade secrets. The court held that the director had breached his fiduciary duties when he used this information belonging to the company, which is regarded as confidential and actually is the property of the company. So, a director also actually make a secret profit by reason of opportunities acquired as a result of his position. So, an example of this, we have looked in the case of Cook versus Dix, whereby the four partners, whereby the four directors which cannot get along with the three directors cannot get along with director number 4, and then they later on form a new company. Remember that case? So under that case, the court held that so this opportunity obtained by the three directors actually, the opportunity to obtain the contract actually came to the directors in their capacity and by virtue of their position as directors to the company, and because of that they were bound to hold the contract on behalf of the company. So in that case, so it does not belong to the new company which they have formed. That is under the case of Cook versus Dix. So in the Malaysian case of Mahasen versus Government Officers Cooperative Housing Society, so in this case, Mahasen was the director of the society. He bought a land for the society knowing that the purchase price was raised exorbitantly to include the commission paid to him. And the court held that the society then was entitled to sue Mahasen for damages since he had breached his duty by taking the bribe. The third conflict of interest is when the directors enter into a contract with the company. So a director cannot enter into a contract with the company because under that situation, he may try to get the best deal for himself. In the case of Transworld Lands Company versus New Belgium Transworld Land and Development Company, two directors of TLC, they were also shareholders of New Belgium. And one of them, who is Samuel, he was also a director of NB, and at the same time, he is also director of TLC. And this Samuel fellow, he recommended to TLC board of directors so that they would agree to purchase a certain shares of NB. And as I told you earlier, just now, he's actually also a director of NB. So after the purchase had been done, then only TLC discovered actually these two directors of TLC, they have an interest in NB. And because of that, so TLC now wanted to sort a declaration to rescind the said contract. And the court held that there was a conflict of interest in this case as both of the director, they are the shareholder of NB, and it's the duty of board director to act actually in TLC's best interest. And under common law, the court have decided actually in the case of Haley Hutchinson's versus Brayhead Limited that the failure to disclose of these interests by the director would cause the contract to be voidable at the instant of the company, meaning the company may choose either to ratify the state contract, meaning they can choose to accept the state contract, or not to accept it, meaning they can actually set it aside at the general meeting. And the director, thus, under that situation, would be accountable for any profits made under the state contract. So under our Malaysian law, under Section 218, Subsection 1 of the Companies Act, a director will be in breach of duty if he has material interest in a contract with a company. And under Section 219, Subsection 1 of the Companies Act, it requires a director to make disclosure in writing of the particulars relating to the shares, debentures, participatory interests, rights, options, and contracts as are necessary for purpose compliance with Section 59. And under Section 221 of the Companies Act, a director has to disclose the fact that he has an interest in a contract with a company, whether it is direct or indirect, to avoid being in breach of his duty through a general notice at the meeting of the board of directors. A direct contract means the director himself contract personally with the company, while indirect contract means the contract includes the family interest or the interest of another company in which the director is the director or the shareholder of that company. And under Section 221, Subsection 12, if the director contravenes the above sections, then on conviction, he will be liable to imprisonment for a term not exceeding 5 years or to fine not exceeding 3 million ringgit Malaysia. And under Section 222, Subsection 1, an interested director cannot actually participate in any discussion while the contract or proposed contract is being considered during the meeting and shall not vote on the contract or proposed contract. So now let us look at the situations under the common law with regards to conflict of interest. So under common law, where there is a possibility of a conflict of interest, so the directors may avoid breach of duty by making full disclosure to the company. So in Fur Limited versus Tom case, it was noted that no director shall obtain for himself a profit by means of a transaction of which he is concerned on behalf of the company unless, one, at all material facts he have disclosed to the shareholders, and secondly, by resolution, a general meeting approve of his doing so, or all the shareholders have acquiescence to this. Therefore, a director may be able to enjoy the profit he obtained out of his position as a director by disclosing his intention and all material facts to the shareholders and getting their consent. If the shareholders refuse to consent, the director can resign and take the opportunity. He will no longer be able as he had disclosed his intention. So what he need to do is that after he have disclosed and the company, the shareholders, refuse to give their approval, he can resign. And after he resign, then of course, he can take the opportunity. He need to disclose first. He cannot resign first under that situation. So only when the director had not disclosed or failed to get the company's consent that the profits he obtained are regarded as secret profit, and as such he has to account for them. This director's duty continues to bind him even after he no longer holds the office. This will be so where the director has, during his term of office, committed acts amounting to breach of duty and he resigns or secure his release in order to reap the benefit of his breach of duty. So this is what happened in the case of Canadian Aero Services Limited versus O'Malley, where the president resigned and take the benefit. So this is wrong. And secondly, or after his resignation or release, he commits a similar act which, if he was still a director, this would mount a breach of duty on his part. So this is what happened in IDC versus Cooley. He resigned, then he joined the company, whereby the opportunity comes to him while he was actually a director, and he did not disclose this. Okay then, these fiduciary duties to whom actually it is being owed, of course to the company as a whole, so, and not to the individual members. This had been decided in the case of W.N. Road, whereby the pension scheme for the wife, whereby the court had actually this is wrong, and in the case of Percival versus Wright, where the court held actually the interest of the company as a whole need to be taken into account. And what are the remedies for breach of fiduciary duties actually? So number one, the company can sue for damages or for the return of the specific property, like the case of Mahesant. And secondly, the company can also claim the secret profit that the director made. So as stated in the case of FIR, if the director disclose it and it obtained the approval, then the director can keep the profit. However, if the director fail to disclose or the director disclose, however, the shareholders refuse to approve, then under the situation, then that secret profit need to be returned back to the company. And thirdly, the exercise of power which is in breach of director duties may be declared invalid by the court. Because why? Because the power which is being exercised by the director is beyond their scope. So meaning, like the case of Howard Smith, they issue share not because they wanted to raise capital. They issue share, however, the objective the issue share is to hinder the other parties from acquiring their share, to take over their company. So this is actually wrong under that situation. Okay, we have completed with the fiduciary duties. So now we are going to go on the second duty, which is actually the duty of care, skill, and diligence. So this is actually under section 213 subsection 2, whereby under the section it is being provided that a director of a company must exercise reasonable care, skill, and diligence. So the standard required to be discharged by a director is assessed based on one, the knowledge, skill, and experience which may be reasonably expected of a director having the same responsibilities. And secondly, if the auditors possess any additional knowledge, skill, and experience which the director in fact has, of course, under the situations, the requirement of this duty will be much more higher. And in the case of Re-Equitable Insurance Company Limited, the judge states that a director must act honestly and exercise care, skill, and diligence. So we are going to go on with the duty to be skillful first. So as just now, under the case of Re-City Equitable Insurance, in this case, whereby the judge said that a director need not exhibit in the performance of his duties a greater degree of skill than may reasonably be expected from a person of his knowledge and experience. This means that there is no minimum standard of skill for a director. The less knowledge he has, the less skill is expected from him. Therefore, The standard of skill varies according to knowledge and experience. If a director has a special skill, example, a lawyer or accountant, of course the expectations under that situation will be much more higher. The Companies Act, in fact, does not prescribe any minimum qualifications before a person can become a director. And the common law also did not prescribe any standard with regards to this requirement. So since there is no minimum standard of skill required of a director, a company cannot expect more out of a director if they have appointed directors who are without skill. So this is what happened in the case of Brazilian Rubber Plantation and Estate Limited. So what happened in that case is this: the directors who undertook the management of a rubber company is actually in complete ignorance of anything to do with rubber industry. And the court held that he is not liable for the loss arising from the rubber speculations, unless the directors were familiar with rubber business. However, in this situation, he is not familiar with this kind of business. So the general rule here, as being laid down in the case of Turcotte versus Marshall, as long as the directors act honestly and within the powers conferred to them, they are not liable for any errors of judgment. So meaning, a director need to be honest, and when he did something, he must do it within the powers which is been given to him. He cannot act beyond the powers. If there is the constitution, of course he have to follow the constitution. So it's very unfair actually to expect an unqualified person to show much skill in the performance of his duties as a director. However, if a director possesses any special qualifications, he is expected to use that skill for the company. So an accountant cannot defend himself by saying that he is not a competent accountant. He will have to show some reasonable skill at par with his qualification and experience similar to what is being done by other accountants. So now we are going to discuss the duty of care. So a director must exercise a duty of care towards the company once he has accepted the position of a director. The standard is of a reasonable care. What does reasonable care means? It means that a director should take as much care in the affairs of his company as he would reasonably take in his own affairs. If he acts in his company affairs in the way no reasonable man would do in his personal affair, then the company can take actions against him. So, as a director, he must care for the company as he cares for his own property. If what he have done as if what he have done towards his own property, then he will not be held liable. So in the case of reciti equitable, the court held there is no single standard of care. A director is only required to display that degree of care that would be reasonable for a person of his experience and qualifications. There are certain general principles actually that may be applied to the directors in relation to the duty of care. Firstly, a director must take the trouble to discover what his rights and obligations are under the Constitution and under the law. And if necessary, he should take a legal advice. So meaning if he cannot understand the law, then he should ask for an advice from a person who is an expert in that field. And secondly, a director is entitled to delegate his duties. If there is no reasonable ground for suspicion, the director is justified in trusting the delegate to perform such duties honestly. So in the case of Huckabee versus Elliott, The appellant was a director of a gaming club that had operated without the necessary license. She was charged for negligence in allowing the club to contravene the law. Her defense was that the running of the club was done by her co-director and not by her, whom she thought must have obtained the necessary license. The court held that she was not guilty, as it was proper for a director to leave matters to the relevant officials, so long as there was no reason for her to distrust the officer. However, if there is reasonable cause to suspect, a director is under a duty then to make reasonable inquiries. If he does not do so, then he has to accept responsibility for the company's loss. So, of course, the liability of an executive director who is being fully employed and involved in the day-to-day management of the company, and most of the time the executive director is a professional, is different from the liability of a non-executive director who involved less in the management and only attends board meetings, and most of the time they depend on the executive director for information as to what is going on in the company. So the liability between these two directors, of course, will be different. So in the case of Daniels versus Anderson, the CEO was being held liable for negligence for not having made inquiries based on the auditor's report. However, the non-executive directors, however, had not been made negligent, as they had not received any information as to the situation of the said company. So we can see this, number one. A director is generally not responsible for the act or omission of his co-directors, even if he did not attend board meeting. However, where he attends board meeting, he must be liable for any decision made in his presence. Where decisions are made in his absence, he will not be liable unless he authorized the act or has agreed to accept liability for it. Secondly, a director must make inquiries when called upon to pay away the company's money. In the case of Railway and General Light Improvement Company, a director noted for a certain payment and he signed the check without knowing exactly what the money was for and without making inquiries which a person of ordinary care in his position would have made was held to be negligent. As I have informed you earlier, under this duty of care, the director have to exercise a duty of care as a reasonable man. And a reasonable man would care for the company as if it is his own property. So under this situation, if the payment is his own money, what he would do under that situation? Would he just sign without knowing what is going on? So because of that, under these situations, the director is being made liable then. So now we are going to look at the duty of diligence, because this is being required also under section 213 subsection 2. However, the degree of diligence required is not specific. It is only being determined based on case law, and of course this is common law. So traditionally, directors are not required to give continuous attention to the affairs of the company. And this duty of diligence actually arose intermittently while performing his function. And in the case of City Equitable Fire, it has been stated that a director was not bound to attend all board meetings, but he ought to attend board meetings whenever, in the circumstances, he is reasonable able to do so. And in the case of Reforest of Dean Coal Mining Company, it was held by the court that directors are bound, no doubt, to use reasonable diligence, having regard to their position, though probably an ordinary director who only attends at the board meeting occasionally cannot be expected to devote as much time and attention to the business as the sole managing partner of an ordinary partnership. But they are bound to use fair and reasonable diligence in the management of the company's affairs and to act honestly. So, directors actually generally need not attend all meetings of the board. However, we can differentiate this between the case of Marquis of Bute, whereby in this case, the director attended one meeting in 2 years and the court held that he is not negligent. However, in the case of Denham, whereby a director who had not attended any board meeting in 4 years was held to be negligent in the discharge of the duties of his office. So this is the last duties of a director. This is the statutory duties. This is the duties which is being laid down by the Companies Act. So here I have laid down 7 duties. So number 1, under section 75 sub 1, so if a director wanted to issue share, they must get an approval in the general meeting. And number 2, under section 219 of the Companies Act, the director also must give a notice in writing to the company with regards to his interest in the company, whether relating to share, debentures, or contracts or any other interest that he have in the company, and whether there is a change in this interest. And under number 3, under section 221 subsection 1, so the directors also need to declare the contract which he have with the company, whether it's directly or indirectly. Directly, he is the one who have this contract. Indirectly, so maybe his family members or maybe his company who have a contract with the company, he have to declare the nature of his interest at a meeting of the board of directors. This is number 3. And number 4, under section 223 subsection 1, so the directors cannot enter into any arrangement with regards to acquisition of a property of a substantial value or the disposal of the substantial portions of the company's property unless it's been approved by way of a resolution. So he cannot simply acquire and cannot simply dispose. So he need to get an approval by a resolution. And number 5, under section 246 subsection 1, if he is a director of a public company or a subsidiary of a public company, so there must be in place a system of internal control that will provide a reasonable assurance that actually the assets of the company are safeguarded against loss and that transactions are properly authorized and that the transactions are recorded as necessary. And number 6, the director of every company shall prepare a financial statement if this is a new company within 18 months from the date of its incorporation and subsequently within 6 months of its financial year. For company which have been formed for many years, so every 6 months, the director must make sure that a financial statement, a financial financial statements is being prepared within 6 months. And number 7, under section 252 subsection 1, the director shall prepare for each financial year a report, and this report shall be attached to the said financial statement.